in, but thank you for joining us this is a first-time webinar called Celebrity Smiles, and I'm really grateful that the Michigan State Law School First Amendment Clinic is providing it to us. So we're going to start, as we always do, with introductions, and I'm going to do the first introduction. So hello, I'm Vicki Elmer, and I am the co-founder of Mint Artist Guild. I've also founded an Italian ice cart, a blog, and a couple of short-lived series that appeared in newspapers. Kelly, would you like to go next?
Hi, I'm Kelly O'Neill. I am on the board of directors for Mint Artist Guild. I also help Vicki with marketing, and I'm currently in the process of launching the new alumni site on mintartistguild.org. I'm also an artist myself. I'm a 3D mixed media artist dealing mostly with recycled metal and abstract sculptures.
Faith, why don't you go next?
Well, hello, everyone. My name is Faith Jones-Honey. I'm one of the Mint artists and part of the Learning Art Group as well. I attend Cass Tech. I'm 16 years old, and I mostly do traditional art, such as, painting and drawing and stuff like that.
And Faith has done 2 interviews with Mint already. One of them, they just dropped in with us at Eastern Market, and one just this past week with WXYZ. Aria, would you go next, please?
My name is Aria Amore Chambers. I'm 16 years old, turning 17 on the 25th of this month. The art that I make, I do digital art as well as abstract. And when it comes to abstract, I don't really think about what I'm doing for real. Sometimes, like, if I'm feeling, I do it based off of my emotions. But when people ask me, I ask them how they feel about it. Instead, because I don't want it to be just one thing. I want it to be something that people can interpret themselves.
Maui, will you introduce yourself, please?
Hi, I'm Maui. I do traditional art, and I attend Cass Tech.
And Jalissa?
Hi, my name is Jalissa Drake, and I'm 17, and I do traditional art, and I sculpt here and there.
Okay. And some of her sculpture was, I thought, was some of my favorite art that we had with us at the Eastern Market. She had a couple of really, really cool pieces. Madeline, do you want to introduce yourself now or a little later?
I can introduce myself now.
Okay.
I actually included a introduction slide as part of my PowerPoint. So hello, my name's Madeline. I'm a second year law student at Michigan State. I'm originally from Des Moines, Iowa, and I moved to Michigan for law school. But before law school, I went to Truman State University, which is in very small town Missouri, for my bachelor's degree. And I studied English and women's and gender studies there. So as I said, I'm in my second year of law school now. And this past semester, I worked in a legal clinic at Michigan State College of Law called the First Amendment Clinic, where I learned about student speech and press rights. And then I traveled to high schools and taught journalism, newspaper, and TV production students about speech and press rights. And through this clinic, I also worked on a legal memo, so a big paper for Mint, which was about right of publicity and copyright issues, especially in regard to the influential Women's Portraits Project. So that's what I'm going to be talking about today, which is the right of publicity and copyright issues and how these apply to you and how you should keep them in mind with current and future projects as artists.
Well, thank you. Thank you so much. So I'm just going to set the stage on this for a minute, and I'm going to ask you to take a minute to imagine this conversation that's taking place at a high school graduation or high school reunion. So let's say it's 10 years after these 2 people have graduated from high school. One of them is an artist. We'll call her Eleanor because, well, Mint always has an Eleanor in our program, and I like the name. And the other is a young musician, and we're going to call her Q because that's what she uses as her stage name. So Q and Eleanor were in high school together, And Q has gotten some celebrity in the past couple of years. She's had some successful music. She's been on a tour, and she's been doing pretty well. Eleanor is still kind of figuring it out as an artist, but she has been making a lot of art. One of the pieces she made was a picture of Q, and the picture was picked up on the front of the local weekly. It's been turned into a poster, it's been turned into some stickers, and it's doing pretty well. So the two meet in, let's say, the ladies' room. Q speaks first. Hey, Eleanor, remember me? Eleanor says, oh, of course. How could I forget you? You're famous now. You're practically famous. Q says, yeah, and you took my face and plastered it all over those all over the place. And I don't know whether I appreciate that. I have the right to my own image, and you took it from me, and you never even spoke to me about it. And Eleanor says, well, wait a minute here. I'm an artist, and I have the right to interpret the world and tell people about interesting and creative people who cross my path through my art. That's what I was doing. I have a whole series about musicians. Yours just caught on, just like your music is catching on. So Q says, well, I don't know. We'll see about that. I have a lawyer who represents me now, and they told me I have the right to publicity. I might have a claim against you. I haven't decided what I'm going to do. Eleanor says, right to publicity? What the heck is that? I've never heard of it. And I really was honoring your work. Plus, it is my work, and I have a right to make work too, and to tell stories through my art. And I'll leave it right there. But that's basically at the crux of it, what goes on perhaps in not so face-to-face ways in many cases when artists make celebrities' portraits and sell them. And with that, I'm going to hand it over to Madeline.
Yeah. So I'm going to be talking about two main issues in this presentation. Before I get into them, if you have any questions at all during this presentation, you can either just blurt them out or put them in the chat, and I'll try and look at the chat. But if I don't see it, you can just ask, because I don't want anyone to be confused about anything while I'm presenting, because a lot of these issues can be complicated, but I'm hoping that I can put it into language which is easy to understand. So the first issue that I'm going to be going over is under Michigan law, can mint artists like yourselves sell reproductions of portraits depicting famous women in the form of prints, calendars, collages, collections, coloring books, or anything else without first obtaining a licensing fee from the individual being depicted or her heirs. So this is basically asking if mint artists like yourselves can sell artwork that depicts famous people without the consent of the famous person that is being featured or their heirs. So an heir is a person that inherits property from an ancestor. So this could be a person's children, for example. I know that right now, many of you might be working on the Influential Women's Project, where you are painting famous women of Michigan like Aretha Franklin or Rosa Parks. However, there may be legal issues with selling images of Aretha Franklin or Rosa Parks or any other famous woman that you are painting without first getting that person's permission. So that's what I'm going to be talking about with that issue. The second issue that I will be talking about in the second half of the presentation is under copyright law, can mint artists create and sell portraits of famous figures in mediums such as paintings, charcoal drawings, and sketches based upon copyrighted photographs taken by a separate artist without violating the photographer's copyright? So this question is concerning issues that may arise when you use a photograph as a reference when you are creating a portrait, and how much of that photograph you can take without running into a legal issue. So Vicki Elmer has shown me some of the paintings that you've been working on. I put two that I've seen up here, and they're all really wonderful. I'm really impressed with all of the work that I've seen. So today I'm just going to be talking about the fact that there may be some legal issues with some of the depictions that you are painting of people. And I know that law can be very complex and maybe scary sounding, but I'm going to try and put these issues into terms that are easy to understand. And I think that you will all be able to get it, because when you break it all down, this stuff can be simple. So it's just very important to be considering these things now through projects that you might be currently working on and in your future career as an artist. These are very important things to understand. Many of you probably don't know what the right of publicity is or what it really means. I had no idea what this was before I came to law school. So I'm going to start off by giving you a brief overview of what the right of publicity is and what this right really protects. Then I'll be going into why you as an artist should care about this. Right of publicity is a type of privacy right. So this right protects against exploitation of a name and likeness of a famous person for a commercial purpose without that person's consent. This means that a celebrity can sue over the commercial use of their name, their likeness, their voice, their signature, or any other personally identifying and unique traits of theirs. An example you can see on the PowerPoint here is an image of Serena Williams that is being used to advertise Wheaties. Wheaties couldn't just slap a picture of Serena Williams on their cereal box without first asking for her permission. And Serena Williams is probably being paid for being featured on this Wheaties box. So this issue applies to Mint because a famous person that an artist depicts in a print that is being sold could potentially sue Mint because their image and likeness is being used for the financial gain of Mint. So for an example, if an artist is painting a portrait of Rosa Parks and is selling reproductions of this portrait, Rosa Parks's heirs, so like her kids, could possibly sue Mint under the right of publicity law. Does anyone have any questions so far? So there are 24 states which have a right of publicity statute. And of these 24 states, 20 of them recognize a postmortem right in the statute. So we'll be getting more into what a postmortem right is in a few minutes, but this basically means that a person's right to publicity persists even after they die. And so their heirs can sue under this right. So when Rosa Parks died, I think in 2004, anything that she had, whether it was like money, her furniture, her house, or her jewelry, her children would have inherited things that she owned. So people who inherit like that are called heirs, like I've said. So like when my parents die, I will be considered an heir, as will my brothers, and will be able to inherit all their property. So just like you can inherit things, you can also inherit the right that that person had. The ownership of your image and likeness is considered a property right. And just like an heir can inherit their ancestors' like property, like their jewelry, they can inherit the right that that ancestor had in their image. And this is something that's true for famous people. So many states which do not have a statute recognizing the right of publicity still recognize this right within common law. So law comes down in many different ways. And one way is that legislators create laws, and these would be statutes. And then another way would be that laws created in court decisions by the judiciary, which would be called common law. So Michigan is one of the states which does not have a statute that outlines the right of publicity, but this right has been recognized in decisions that are made by Michigan courts, which would govern the right of publicity law. So when I was doing research to understand the right of publicity law in Michigan, I was looking to prior decisions made by Michigan courts about the right of publicity, and also to statutes and cases which fall within the Sixth Circuit, which is where Michigan is located. The United States breaks up their courts into different circuits. So Michigan is located within the Sixth Circuit along with Ohio, Kentucky, and Tennessee, I think. So that means that if there's a decision or a statute in Ohio, this could probably make an influence on decisions that are made in Michigan too. So states in the United States are split up into different circuits, like I said, and the United States Sixth Circuit, where Michigan is, has developed a two-part test to determine whether a violation of the right of publicity has occurred. So the person who is suing must show that their likeness, so their image, their character, their trait, their name, their voice, anything like that, like a unique identifiable trait, was used without their permission, and that the person who used their identity is making money off of that use. And this would be money that the person who's being appropriated, so the person whose image is being used, would have made money off of, but they're not, because this other person is using their likeness. Does anyone have any questions so far? I know this is a lot of information I'm spitting out right now, but we're going to go into some examples in a little bit that will bring this to life and make this easier to understand. So using a person's likeness for a commercial use means that a person's image is used for some sort of financial gain. This could include like an advertisement on the TV or radio, a testimonial that suggests that an individual eats a certain cereal or drives a certain car, or a person's image used on a website banner. So for Mint, if a print or a portrait is sold for profit in connection with Mint, this is a commercial purpose. And I understand that many of the profits that are made from selling prints and reproductions of artwork from artists are used to purchase more materials for Mint, to hire interns to host events and things like that. And when I was doing research on this issue, I kind of thought that that could fall under fundraising. And fundraising does still count as a commercial purpose. So fundraising has fallen into the category of a commercial purpose in a number of other statutes and states outside of Michigan. And so it's very likely that this fundraising could be considered a commercial purpose in Michigan. So coming back to this idea of postmortem rights, having a postmortem right in right of publicity law means that that right of publicity survives the death of the person. So this means that even after the celebrity has died, that person's heirs can sue for right of publicity. Michigan's common law, so like the law that's created in the courts, recognizes that the right of publicity persists in a person even after they have died. So going back to the example of Rosa Parks died in like 2004, 2005, I believe. But that doesn't mean that Mint can sell reproductions of portraits of Rosa Parks for financial gain without consent. Rosa Parks' heirs can still sue Mint under right of publicity because Michigan recognizes that Rosa Parks has a postmortem right in her likeness. This is very important because looking at like the Influential Women's Project, for example, I understand that many of the women that could be depicted in this project are deceased, but even if you're creating a portrait of a woman who's deceased, this right of publicity is still applicable. So you still need to keep this in mind when you are creating your artwork. So courts have employed something that's called the transformative work test to determine that a celebrity's likeness can be used when an artist uses creative elements to significantly transform the message and the meaning of the original work. So an unauthorized use of a celebrity's likeness may be permissible if the work adds significant creative elements to the celebrity's likeness and transforms the celebrity's likeness into an original expression. A very literal depiction of an individual is unlikely to be considered transformative, such as like a pencil sketch or a charcoal sketch of a photograph. A depiction which makes commentary on that individual through creative elements will likely be considered transformative. So for example, a portrait of Aretha Franklin with a crown on her head and lyrics to the song Think around her might be considered transformative as opposed to just a very literal charcoal or pencil sketch of Aretha Franklin. I'm going to be going over some examples of this in the next few slides. But basically, this test means that if a use of a famous person's image is transformative, the artist may not need to get the famous person's consent before selling their work. All right, so going into the first example, all of the examples I'm going to be going over are based off of cases. So I'm going to talk to you a little bit about like the background of the case, and then we're going to discuss the actual artwork. So this is from a case called Gary Satrap versus Comedy 3 Productions, and this came down in California in 2001. So Comedy 3 Productions is the registered owner of all the rights to the former comedy act, The Three Stooges. And Gary Satrap is an artist who makes charcoal drawings of celebrities. These drawings are used to produce reproductions in the form of prints and silk-screened images on t-shirts. In this case, without the consent of Comedy 3, Satrap sold images and t-shirts which had the likeness of the Three Stooges on them. So you can see on the left is an image of the Three Stooges just for your own reference. And then on the right, you can see the charcoal sketch of the Three Stooges that was created by the artist Gary Satrap. While these cases did not mention if these portraits were taken from, if this portrait was taken from a photograph, you can see from the image on the left that the depiction of the Three Stooges in this charcoal sketch makes it appear that it's very likely that this could be based on a photograph. It's a very literal depiction of the Three Stooges. These expressions on their faces are like, you look up the Three Stooges on Google, these are like what their expressions look like in mostly every photograph. So the court in this case applied the transformative work test. And when we're applying the transformative work test to write a publicity cases, we are asking if the portrayal of the person is just a literal image of them, or if the portrayal is creative and original. So here, the court used the test to ask the question of, do the literal and imitative or creative elements predominate the work here? And the court found that they were not transformative, and there were not really any creative elements in this Three Stooges piece that went beyond the literal image of the Three Stooges. This is a very literal depiction that was drawn in charcoal. And so here, the transformative work test did not apply, and the artist Gary Satrap was in trouble for a right of publicity issue. So in contrast, some reproductions of celebrity portraits are protected because they do contain significant transformative elements. The court in the past case pointed to the artist Andy Warhol as an example of an artist who created portraits of celebrities. Up here, I have portraits of Marilyn Monroe, the musician Elvis Presley, and actress Elizabeth Taylor as an example. And the court talked about how these portraits contained a message of social commentary about the dehumanization of the celebrity. And I have just some pictures up here of the celebrities that you can use as reference when you are comparing the literal image of the celebrity to Warhol's portraits of them. So either in the chat or by unmuting yourself, if you can think and then tell me what you think Warhol is doing in these images of Marilyn Monroe, Elvis Presley, and Elizabeth Taylor, that's different from Satrap's depiction of the Three Stooges in the past slide. So think about the message behind these Warhol pieces and about the creative elements that Warhol employs in these portraits that are absent from the Three Stooges piece. I'll give you a minute, but you can unmute yourself or type in the chat when you're ready if you have any ideas.
So go ahead and put something in the chat about what you think makes this different than the previous example.
Yeah, so in the last example, they said that that was not transformative enough. And in this example, they're saying this is transformative enough. And this has a different message beyond the just literal image of the celebrity. So why do you think that is? What's different about Warhol's pieces? Okay, so Kelly said, I don't think this is transformative at all. It just looks like a recolorization. He added bright colors. It's more colorful.
Yeah, I would have to agree with everybody else. It's just the difference in color.
Yeah. Seems like there's some commentary on celebrity and beauty. Yeah, so you are all right that the color here was a big part of these. So looking at the difference between what Marilyn Monroe looks like literally and then what she looks like in Warhol's depiction, he uses very bright and vibrant colors, and he kind of flattens out their features and takes away any like detail and lines on their face and really like glamorizes them through those colors. They don't really look human anymore in these images. So the commentary here was the dehumanization of the celebrity.
Yeah, Maui just wrote that it looks like they're sort of posterized.
Yes, absolutely. Yeah, they don't really look like real people anymore. They look fake.
But because, just a comment, of course, Andy Warhol did this with silk screening many, many years ago before there were, computer apps. And, you could do this with a simple app. So I wonder if the courts would have ruled differently today, because today I could take any image off the internet and do an app on any celebrity within 14 seconds and then sell that likeness for profit. So I'm wondering if the courts would rule differently. And also, Andy Warhol was Andy Warhol. So I'm sure his artisanship and his own celebrity probably was part of the decision too.
That's a really good point. Yeah. And I didn't know that you could do that just through a computer app. I'm not an artist, so that's a really good point. All right, so the next example we're going to look at comes from a case called ETW Corporation versus Jair Publishing. And this is a case from the Sixth Circuit, so where Michigan's located, and it was decided in 2004. So ETW is the licensing agent of Tiger Woods, who's the famous golfer, and Jair Publishing is the publisher of artwork that's created by the artist Rick Rush. Rush calls himself America's sports artist, and in 1998, he created the painting, The Masters of Augusta. So that's this painting right here, which honors Woods's victory at the Masters tournament in Augusta, Georgia in 1997. So in the foreground of the painting here, you can see three views of Tiger Woods in different poses. So him crouching down here, him swinging his, oh my gosh, I'm blanking on the word. His
putter, yeah.
Yes, yeah, him swinging his putter and then him crouching down again here. So behind this is the Augusta National Clubhouse. So that's this building right behind him. And up here, you can see the likeness of famous golfers in the past who are looking down on him, such as I think Arnold Palmer might be that one. I don't know a lot about golf. And then, yeah, these would be all different famous golfers. And then behind them, so right up here, you can see the Masters lead board. So this print was sold by Rush's publishing company. So before I tell you what the court decided here, I want to know what you all think. Do you think that this image created by Rush is transformative enough? And if you think so, why do you think that? And if you don't think it's transformative, why don't you think it's transformative? And as reference, here's just a picture of Tiger Woods that I pulled off of the internet, which is very similar to this right here.
So you're welcome to either unmute yourself, or if you'd rather put it in the chat for all you introverted, shy artists there. What are your thoughts on this piece? The piece on the right.
While they're typing, I got a question for you. So I'm assuming there's a difference here in the sense that the artist is the one who has a publishing company who's selling this, versus if this particular image was then used in an ad for Titleist, would they have had to have paid Tiger Woods and the estates of all those famous golfers?
Would the person who used it in the advertisement have had to pay?
Would, if I were Tiger Woods and this particular image was used in a Titleist ad, I would assume that Tiger Woods lawyers would have asked for compensation from Titleist.
Yeah.
Yeah. So I think the difference here is like maybe because it's transformative in the idea of like, you know, they're looking down upon him and it's a piece of art telling a story, that the artist himself might have some leniency. But if this image was used in a commercial sense to sell golf attire or golf equipment, then I think the celebrities might have a claim.
That's a good question. As far as I know, I think that the transformative work test here would apply either way, but if this image was being used to sell a product, then I do think that they would need to ask for permission, because you don't want to put out this image that Tiger Woods supports a product that he might not know of or might not support. Did I understand your question correctly?
Yeah, I think it's a different scenario being an artist selling it because I'm telling the story here with a piece of art versus I'm using this art to sell a product. And that's why the reason I'm asking is I think almost the difference between what an artist does for Mint and selling their art versus Mint using the artist's work and selling it for profit.
Yeah. So an artist could, I think that an artist and Mint could both still get, so if an artist was selling their work, so if an artist was selling this, and let's say that the right of publicity that they were liable for the right of publicity here, the artist would be liable if they were just selling it themselves. But then if Mint were selling an artist's work that they were liable for the right of publicity, then Mint would be the one who was liable and not the artist, I believe. Okay, so Jalissa pointed out that this is like a collage of the guy and thought that this was transformative. And then Aria said that this piece was transformative because the artist is showing off Tiger Woods' career. Yeah. Here, yeah, the Sixth Circuit adopted the transformative work test and determined that the transformative work test did apply here. So applying it here, Rush's work consisted of much more than just the mere likeness of Tiger Woods. It celebrated the culture that was attached to the Masters tournament. So like Aria said, showing off like the career and then celebrating this tournament. And it also depicted the likeness of the past 6 winners of the Masters tournament up here. And it kind of conveys a message that Tiger Woods is going to be joining that group of famous golfers. And it also was, like Jalissa said, a collage of images in addition to just Woods's likeness, which was being used to describe a historic event. So this contains significant transformative elements, which made it worthy of full protection with the transformative work test. So here, the artist would not be liable for right of publicity.
I want to add that I think that example is a really strong example to keep in mind because of how transformative it was. Not all of your pieces will be that elaborate, but it did have so many elements that were that made it into, as Kelly said, a story, the full story, and not just a literal depiction.
Yeah, that's a really good, and after I'm done going over these examples, I'll go kind of back to that and we'll talk about like what kind of art could you produce that would pass the transformative work test. And that's a really great example of a piece that you should look to. So next, I'm going to be getting into historical and educational significance. So a work can also be protected from right of publicity infringement if it has an educational purpose and is historically significant. So the art in question must promote the human, their historical context and importance, and the work must be educational. It can't just make money off of their name. So here we're going to be looking to the case of Rosa and Raymond Parks Institute for Self-Development versus Target as an example. So this is a case that came down in 2016. Rosa and Raymond Parks Institute for Self-Development is a Michigan nonprofit corporation that owes its name and likeness to Rosa Parks. And Target, as we all know, is a national retail corporation, and it's headquartered in Minneapolis. So Target was offering several books about Parks for retail and sold a movie about Rosa Parks and a collage-styled plaque that included Parks alongside Martin Luther King Jr. So you can see that plaque is the picture that's right here. And this was created by artist Stephanie Workman Murat, who's a professional artist. And in November of 2013, the Institute sued Target for using the name, likeness, and image of Rosa Parks without consent to promote and sell products for a commercial purpose. The court here held in favor of Target. So the court stated that the use of Rosa Parks' name and likeness in the books, movie, and plaque is necessary to chronicling and discussing the history of the civil rights movement. So Rosa Parks is a figure of great historical significance, specifically to the civil rights movement, which is a matter of legitimate and important public interest. So essentially, the books and plaque did not just copy a photo image of Rosa Parks, but they put her in a historical context and placed her in a cultural political movement that she helped to define. This decision kind of reflects the discussion of the transformative work test that we've been talking about. So while the court here did not specifically use the word transformative, it reflects a really similar discussion. And here the transformative element would be their educational purpose on a historically significant figure and period of time. So applying this to Mint's work, a lot of you maybe, especially for the influential women's portraits, are going to be creating art that depicts the image of a woman who has probably had a cultural or historical impact, like Rosa Parks, Aretha Franklin. I think one was a doctor in Michigan who was really big in the COVID-19 crisis. One way to make these portraits transformative would be to place that person in a historical context in the artwork, and to kind of use your portrait of them to tell or explain the historical or cultural impact that they have made. And I'll be going over later on kind of some examples of what that could look like, but that's the impact that this is going to have that this case would have on your work. In this next slide here, we're going to be getting into the topic of the title of a work. So as an example, I'm going to be discussing the case of Parks versus LaFace Records, which is a Sixth Circuit case that was decided in 2003. Rosa Parks sued record producer LaFace Records and musicians Outkast for using her name in the title of a song. So the song was entitled Rosa Parks. I have included some lyrics from the song on the board here. And if you could read over these lyrics and then tell me in the chat or through unmuting yourself if you think that these lyrics have anything at all to do with Rosa Parks. And I apologize, some of the language in these lyrics is a little crude.
So the question you're answering in the chat is basically, does the title Rosa Parks, is it reflected accurately in the lyrics? Right? Is that right?
Yeah. Do you think that these So this song is entitled Rosa Parks, but do you think that the actual song has anything at all to do with Rosa Parks? And I've only included part of the song here, but this is basically what the entire
Yeah.
song is like.
No, it's kind of defamation of character. It has nothing to do with her and puts her in a bad light. Yeah,
Yeah.
I would be upset if I was responsible for her estate.
Absolutely, yeah.
The only thing that has anything to do with Rosa Parks is the part where it says everybody moves to the back of the bus.
Yeah.
And
Yep.
everything, like from that point on, it just started talking about going to the club and all this other stuff.
Yeah, exactly. And yeah, you pointed out that line, and there's like one more line later on in the song that is kind of like that too. So there's only 2 lines in this entire song that's entitled Rosa Parks that maybe have anything remotely to do with Rosa Parks. So it could be really misleading for people who see this song and think that it's going to be about Rosa Parks and then listen to it, and it is not at all about Rosa Parks. And like Kelly said, could be like defamation of her character. So, oh, I apologize for that. Here, the court was talking about how the relationship between the title of the song, Rosa Parks, was really unrelated to the actual content of the song, and that the creators of the song did not intend the song to be about Rosa Parks when they entitled it after her. The court stated that this song infringed on Rosa Parks' right of publicity because her name was being used solely to attract attention to the song, but the content of the song was not actually related to her. So bringing this and applying this to mint artists, you should all note that if you entitle a portrait after an influential woman from Michigan, the artwork in question must be related to the life and person that it's entitled after. So, for example, if you are entitling a work Rosa or Rosa Parks, it must clearly be about Rosa Parks and not issues that are like super remotely related to her. A work can be violative if the title has no artistic relevance to the underlying work whatsoever, or if it has some artistic relevance, but the title is explicitly misleading as to the content. So translating this to an art piece or an actual image, an example could be if you're painting an image of a random African-American woman who's depicted straightening out her natural hair while looking down at a magazine that's called Professional Hairstyles, with pictures of white women with straight hair across the page. So while this shows discrimination that African-American women experience and face, this would be too far removed from Rosa Parks' name and story to entitle this Rosa Parks. So up until now, we've been talking about the right of publicity, which is a privacy right that applies to famous people. However, even non-famous people have a right to prevent the use of their likeness for a commercial gain of another person. And this right would be called misappropriation. So artists also must adhere to appropriation laws when they're depicting individuals who are not famous. So to succeed in an appropriation lawsuit, the following elements must be proven. And this would be 1, that a person did not consent to the use of their identity. 2, an artist used a protected aspect of the person's identity. And 3, the artist used the person's identity for their immediate and monetary benefit. If artists choose to depict specific non-famous living individuals in their artwork, and they choose to distribute it and reproduce it, they must first seek permission from the individual that they represented, as long as the work is not transformative. So if the work is transformative, and there are elements that substantially and materially change the content of the work, the artist will likely not be liable for misappropriation. So the transformative work test that we've been talking about applies to misappropriation the same way that it applies to the right to publicity. Also, artists can depict individuals within their work who are construed from their imagination. So if you are creating a piece of artwork and the person that you're painting is not a real person that you know in real life, they're just someone that you made up in your head, that's totally fine. You don't have to worry about anything with that.
What if you were to do something, you're trying to do something funny. So instead of Rosa Parks, it's Posa Rarks. And it's looks someone like her, but she's a cartoon character. Could you get in trouble for that?
I think you could, because I think it would be pretty obvious that you are basing this off of Rosa Parks, especially if the cartoon character looks like her and depicts like the likeness of Rosa Parks. I think that could still, I think that you could still be in trouble for that, unless there was some sort of parody law would be something that could maybe apply here. But that's a more complicated issue to get into. But just to answer your question simply, if you're creating something that's called Posa of Arcs and has an image that looks exactly like Rosa Parks, I think you can still get in trouble for a right of publicity issue there.
So Madeline, Maui has a question. If the artwork depicts a celebrity, but it isn't being sold, does the right to publicity still apply?
No. So the right to publicity only applies if there's a commercial gain. So if there's some monetary benefit to it. So if you're just creating artwork that depicts a celebrity and you're keeping it for yourself, or you're giving it to someone else for a gift, not making any financial gain from it, then the right of publicity doesn't apply. The right of publicity only applies when you are selling this for like a monetary financial benefit. Does that make sense?
So could you still enter it into a contest or something?
So there is something that's called, I think it's the right to first sale. So if you are, and this is getting into some complicated issues, but if you are just selling that like original piece that you make, that's usually okay. The trouble that you're running into with right of publicity is when you're selling like reproductions. So you make a piece of art and then you make a bunch of reproductions of it and sell those. That's where the right of publicity would apply. But the right of first sale, I think that you could still enter it into a contest, especially if that contest, you're not making any financial gain from it. I would think that would totally be fine. And it would especially be fine if that's like your first product. You haven't made any reproductions from it. Okay, so we're going to go into an example of misappropriation, and this would be an example that has to do with nurses. So up on the board, I have 3 different pieces of art that depict a nurse. And let's just imagine here that these are all of the same nurse, and the artist did not get permission before reproducing and selling prints of these pieces. So right here would be our first work. This is our second work. This is our third work that was created by a mint artist. And of these, do you think that any of these would be transformative to sell, and why or why not?
And go ahead and unmute yourself and offer your perspective, or go ahead if you'd rather put it in the chat. The third piece was created by Alexis Bagley in the Midsummer Jobs 2020, by the way.
Okay, so the third one, because it's not as realistic. So it being not as realistic, that's a really great point. The transformative work test, though, will still apply to pieces that are very realistic. So this piece right here is and this piece right here are both really realistic, but that doesn't really apply to the transformative work test, because something can still be super realistic and be protected because it's transformative. Does anyone else have any other thoughts on which of these pieces might be protected with the transformative work test and which ones might not be?
Faith, what do you think?
They all would, because, well, in the 2 on the left, they have the mask, so you really can't identify who it is. And the one in the middle, like, it's surrounded by the superheroes, which aren't technically real characters. So I think that those 2 will still like pass the test.
Yeah, it's a great answer. And then Aria in the chat said that the third is transformative and looks like an original character or a non-realistic drawing of the artist. Okay, so those were all great answers. Here in this example, we're saying that if a mint artist chooses to paint a very literal portrait of a specific nurse from a Detroit hospital and sell reproductions or prints of this work, the artist is going to need to ask the nurse's permission before painting and selling those portraits. So we're imagining in all of these that this is an actual real nurse that's being depicted and not just like an imaginative figure. So here, this artwork would not be considered transformative because it's a very just literal depiction of this nurse. There's not really any other transformative elements beyond just her literal image being used. These two pieces, however, have a message that goes beyond just the literal depiction of that nurse. They both have a message that nurses are superheroes. So if an artist chooses to paint a nurse that's wearing a superhero outfit with the letters RN printed across her chest in a gold Superman-like medallion with a blue cape flying out behind her to show that during the pandemic, nurses became kind of superhero-like figures. This depiction is likely going to be transformative because it would not be necessary for the artist to seek permission. This work would especially be transformative if additional elements were added, such as patients in hospital beds, individuals wearing face masks, protective gowns, needles carrying the COVID-19 vaccine, things that would be representative of COVID-19. So both of these images here kind of give across that message that a nurse is a superhero-like figure. And especially right now during the pandemic, this would have an even stronger message because of everything that nurses have contributed to our society, especially now in the midst of a crisis. Does that make sense? So here we have the very literal image, and then this has a message that's beyond just that literal image. And you can see that with elements like here, the elements would be that she's surrounded by other superheroes. And then here it's the medallion across her chest. She's in the superhero-like pose. Those are different elements that you can add, or examples of elements you can add to make your work transformative. Oh, and then I'd also like to add that if those nurses were people that were just completely from your imagination, then you wouldn't have to seek any permission. There would be no one to seek permission from. It would be totally fine. So if you were I want to create an image of a nurse and show that this nurse has become a superhero on the pandemic, but you're just doing a nurse that's in your imagination, then that's totally fine. Okay, so you're probably wondering right about now what you as an artist can create that can be reproduced and sold with Mint. Artists should not sell literal depictions of individuals, such as pencil or charcoal sketches of photographs, as part of the Influential Women series or any other project that you do without first obtaining a license from the women or her heirs, like her children or any other descendants who might be considered her heirs. So to avoid obtaining a license, each portrait must contain significant creative elements which transform a literal depiction of the individual into an original work, which conveys a message beyond the person that's depicted. Mint artists should look to the work produced in Satirap. So that would be this one right here. No, Satirap was the Three Stooges one. As an example of a portrait which would infringe on an individual's right to publicity. So this image of the Three Stooges was literal and lacked a creative expression beyond the persona of the Three Stooges. The portrait of the Three Stooges contained no commentary or message outside of the literal depiction. Celebrity portraits by Andy Warhol were an example of transformative work, such as Marilyn Monroe, which I have right up here, because they used vibrant, unnatural colors and frequently used themes of repetition and to make a social commentary about the dehumanization of the celebrity. So these contained a message beyond just the literal image of the celebrity and would not infringe on the right to publicity. Mint artists must also be careful not to go so far in their message that it becomes unrelated to the woman. So in the example of the song that we talked about, that would be an example of the title and how that title needs to relate to your actual work. So for example, a mint artist could not sell a piece of artwork that was entitled Rosa Parks or Rosa, which only featured images of the George Floyd Black Lives Matter protests, which took place in the summer of 2020. But a painting entitled Rosa Parks or Rosa should have a clear relation to Rosa Parks in her life. So an artist could create a painting of a picture which depicts an image of Rosa Parks at like the top of the canvas, looking down on a portrayal of the Black Lives Matter protesters, or an image of George Floyd illustrating her legacy and the path that she paved. That would be that would be an okay representation of Rosa Parks, because while you are still having a message that has to do with Black Lives Matter protests, with that image of Rosa Parks looking down on it, it would be related to Rosa Parks and would tell a story about the path that she paved. As examples, mint artists should look to the work created in ETW Corporation. So that would be this one of Tiger Woods, and the Rosa Parks Institute, so that collage of Rosa Parks that was sold by Target. These are montages and collages of images that evoke a celebrity's image and are surrounded by words or pictures that denote their legacy. And these images do not infringe upon one's right to publicity because they contain an original message that's beyond the meaning and literal depiction of the individual. Okay, I've got some more examples here. So here I have 3 examples of work which could be protected with a transformative work test, and you can go ahead and read those over. I would just like to say that I'm not an artist, I'm a law student. So these might be cliche. These are just things that I came up with when I was doing this. You all, I'm sure, could do much better than any of these. Because like I said, I'm not an artist. Anything that you will do will probably be 100% better than anything I would be able to come up with. But they're kind of just examples of what could be done. Adding images around a person, including like references to their historical legacy, could be transformative. So that's a good thing to keep in mind. And I would also like to know that there's not really a cut and dry rule here. You might be wondering, well, how much do I need to add to make a piece transformative? How many different elements do I need to add here to make my piece of work transformative? And there's not a cut and dry rule there. So for some pieces, you may only need to add one image or some words or colors to convey the message that you want to, that goes beyond that literal depiction of an individual. But for other pieces, you may need to convey, you may need more to convey the message that you're wanting to give. How much you are adding really just depends on what message you are trying to give with your artwork and what you're trying to convey through your artwork. There's not a hard and fast rule for that.
I just want to clarify, if I paint a straight portrait from a photographic reference of someone famous, that would not be transformative. Is that a correct statement?
Yeah, so if you are using a photograph as a reference and paint an image that comes from that photograph and it's just like a very literal image, then that would not be transformative. You would need some other elements that give a different message that goes beyond just like that literal depiction of the person. And then also using a photograph as a reference is something that we're going to be going into next with copyright infringement. because there might be some copyright issues with like using someone's picture as a reference when you're creating and selling portraits.
I do have a question.
Yeah.
I drew something like a while ago, and I was wondering if it was like considered transformative.
Oh, that's beautiful.
Thank you.
I can't see the image super well.
Sorry.
So when you were creating that image, were you basing that off of like a photograph?
Yeah, it's a picture. It's a photograph.
Okay. So I would say, so you have some colors there that make that pop, but I would say that probably to make that image transformative, you'll probably need some other elements that go into it that would have like a message and meaning that goes beyond just like the image. So you could add some elements that would make a commentary on that person. You could add elements that talk about the impacts that this person has had, or what kind of image or legacy they have, or what cultural impacts they've had. But I would say that that does look like a pretty literal image, so you probably would need some extra something in there to make it transformative.
Yeah, what I took away, because I spent quite a bit of time on this earlier when we were working on the legal brief and thinking about it, was you want to give some context, some storytelling, some impact, some historical significance, or even significance in your personal life. And if you do that, that makes it a more original, transformative piece, as opposed to just a literal depiction.
Yeah, absolutely.
Yeah.
I have a question, but I'm not sure if it falls under write-up publicity. Would this would it apply to like logos and like brand names as well, or just like images of people?
So write-up publicity is only concerning people. What you would be talking about with brand names would be something called trademark. I don't know a lot about trademark law, but I think that I don't want to say anything definitive because I don't know much about trademark law. I can look into that and get back to Vicky about that. But trademarks don't have anything to do with write-up publicity. Write-up publicity would just be about a person and their image, or any other like identifying traits. So like their voice could also be write-up publicity. All right, so I'm going to move into copyright law now. So not only must artists be worried about right to publicity, but they also must be avoiding issues with copyright infringement. So first, I'm going to start off by giving you a brief overview of what copyright and copyright infringement mean. And then we'll be going into some examples, just like I did with right of publicity. So a copyright concerns artistic and literary expression. A copyright is something that gives a legal right to the creator of a creative work. Copyrights protect the value of a creator by giving the creator of the work the ability to protect it from unauthorized duplication or use. So for example, the author of a book has a copyright over the book that they wrote, and this copyright will give the author the legal right to protect that book from it being duplicated, copied, or used without their permission. Infringing on a copyright occurs when someone uses or duplicates a copyrighted work without permission from the copyright holder. So as an artist, you could be subject to copyright infringement if you copy what is in a photograph and paint a piece deriving from that photograph. So in other words, you cannot merely like recast a photograph into a new medium, like charcoal drawing or a painting. This is not to say that an artist cannot look to photographs already taken of an individual for their inspiration or for research. An artist painting a portrait of Ruth Ellis, for example, may adopt the features and expressions from photographs of Ruth Ellis and apply these to an original portrait. However, the artist cannot reproduce an exact replica of that photograph as a painting of Ruth Ellis. Yes, the exception would be if you took the photo yourself. So if you took a photo yourself and then you make a painting based on the photo, you're the copyright holder of that photograph. So you're not violating the copyright if you're painting a derivative of that photograph. So fair use is a very complicated part of copyright law. And I could spend like this entire webinar talking about fair use, but I'm just going to give a brief overview of it so that you can understand how fair use applies to some later examples. And if you have any questions, please type it in the chat and I'll do my best to answer. So fair use means that a person can use a copyrighted work without permission under certain circumstances. So this would include criticism, comment, news reporting, teaching, scholarship, or research. So for example, some of the images that I've used in my PowerPoint presentation were images that I took off of the internet, and this would be considered fair use because I'm using them for the purpose of teaching. So courts look to the following factors that are listed right down here to determine if the fair use doctrine is applicable. These factors ask, so first, did it change the message and meaning? So did the second work change the message and meaning of the first work? 2, how much protection does the original copyrighted work get? 3, how much did the second work take from the first work? And 4, does the second work have an economic impact on the first work? So does it take away from the sales or money from the first work? And I know that this is complicated, but like I did last time, I'm going to go into some examples now that hopefully make this easier to understand. Copyright is super confusing to me when I was doing research on it, and fair use was, so I get it if this is confusing. So the first example I'm going to go over is a case called Carew versus Prince, and this was decided in 2013. Here, the artist was Patrick Carew, and he published a book entitled Yes, Rasta, which contained portrait and landscape photographs that Carew took while living among Rastafarians in Jamaica. Richard Prince is the second artist here, and he used several of Carew's photographs in a series of paintings and collages, which he exhibited and also sold in an exhibition catalog. Carew sued Prince, stating that Prince's use of his photographs infringed on Carew's copyright. So down here, you can see what some of the photographs that were originally taken by Carew looked like. So the court in this case held that, so there were 25 works that were created by Prince. So Prince is the second artist who created artwork that was using Carew's pictures. And the court held that of these 25 works using Carew's images, 20 of them were so transformative to a reasonable person, and they manifested a different aesthetic. So the fair use test applied here, and they were okay. So Prince wasn't in trouble for creating them. On this slide, you can see a few of the images that were considered fair use. So these were considered to have a different character and different aesthetic, and the court said that they were creatively and communicatively distinct from Carew's original photographs. And on this slide, you can see a few images which the court held were not fair use because they were not transformative enough. So in these works, the underlying work of Carew was not substantially altered by Prince. The underlying work was too recognizable. So I'm going to use this work down here. It's called Graduation, and I'm going to use that as an example. In this work, so this is the original work, and this would be Prince's work that he created. So in this, Prince merely was adding like blue lozenges over the person's eyes and mouth, and they added the guitar there. But you can see that the man and his surroundings remains like fully intact in this work, and that Carew's image was completely recognizable. So if you go back to the fair use images here, you can see that these people are completely taken out of their original surroundings. This is the same man that was in that graduation work that I pointed out to, but here he's taken out of his original surroundings in the jungle. He's placed amongst other images with a red background. You can't see his eyes anymore. He's not as the underlying work that was created. So Carews' original picture is not as recognizable in this image as it is right here in this image. So looking at these non-fair use images, what is notable is that in each of them, the subject in the photo is recognizable in the original setting that Carew first put them in. However, in the fair use images, and I'm sorry if I keep going back and forth, in the fair use images, the bodies of the individuals are completely taken out of the original setting that they were photographed in by Carew and put in a new context and placed amongst other images. And he like cut out like different parts of images and kind of like put them together to make new images. So here, a chest of one image was cut out and put over the chest of this image to make a new work. In the fair use images, Prince takes parts of Carew's images and pieces them together along with his own background and colors to make new and original pieces. So looking at this case of Carew versus Prince, mint artists may likely use photographs of the influential women or any other person that you are depicting if their first work transforms the message or meaning of the, if their work transforms the message or meaning of the first work. So for example, a mint artist could paint an image of a photograph taken of Diana Ross if the artist added images, colors, words, or more, which transformed the message of the original work, making the second work original and transformative of the first work. And I also want to note here that I've used the word transformative in copyright law and in right of publicity. And you might be confused with that word being applied both places because it means something kind of different in each law. So sometimes in law, the same term is being used, but it doesn't exactly mean the same thing for each kind of law. So for your purposes in right of publicity law, the word transformative is about the literal depiction of a person and going beyond that literal depiction. And in copyright law, the word transformative is about the message and the meaning of the original work, and if that message and meaning changed in the secondary work. So the second case I'm going to be going over is the Andy Warhol Foundation for Visual Arts versus Goldsmith. So this is a very, very recent case. It came down in 2021. I think it was March, or it's either March or August. I know those months are far apart, but that's what I have in my head in 2021. So in 1984, Vanity Fair licensed with a photographer, Lynn Goldsmith, to have a photograph she had taken of Prince, the rock musician, to be used and manipulated by artistically well-known Andy Warhol. You can see the photograph that Goldsmith took right here. And then right here on the right, you can see the article that Vanity Fair published, and this was alongside the photograph of Prince, or the image of Prince that was created by Warhol. And this was the image that was licensed. So this was the image that Goldsmith like, okay, like, yes, you can use my photograph to make this image for this Vanity Fair article. I'm sorry, it's a little bit blurry, but I think you can. So you can see on this slide the licensed image that was created. But without the knowledge of Goldsmith, Warhol also created 15 additional works that was based off of this original photo, and they called it the Prince series. And Goldsmith didn't find out about these 15 other works until Prince died in 2016. Goldsmith sued for copyright infringement on these 15 additional works that were sold and distributed because they were not a part of the original licensed original license with Vanity Fair. So just to make certain that everyone's understanding, this image right here was licensed and okayed, but Goldsmith didn't okay the fact that Warhol would be making 15 other pieces based on her photograph. So she's suing about those 15 other pieces that were sold and distributed for profit.
I just want to interject. For those who don't know what licensing is giving an entity like the magazine or like a company a limited use of the work for some specific purpose and usually for a specific time. So you could license a piece of art you made to Hallmark for a card, and they could use it for whatever period of time the license covered, or you would license it to somebody who would put it on tea towels or on hoodies, and you would give them the right to use it for something specifically.
Yes, thank you. So you can see on here a few of the unlicensed images that were created in the print series. So these were a few of the 15 images that were created without Goldsmith's consent. The question here is whether these 15 additional images infringed on Goldsmith's copyright of the first photograph. So before we move on to the next slide, I want to know your opinion. Do you think that Warhol violated Goldsmith's copyright on the original photograph? And think about here the message and meaning in the first photograph and whether that changed in these second photographs. And you can also think about how, thinking back to Carew, think about how recognizable the underlying work here is in these images.
Well, I think kind of Vicki explained it well. When you license something, there's parameters that you agree upon. And in those parameters, it was for a single use for a Vanity Fair article. And he went beyond those parameters, and therefore he did infringe.
Yeah.
So that's my thought.
Yeah. Yeah. And so the defense then, if he did infringe on that copyright, would be if like these works were transformative enough, so then like the fair use test would apply. So looking at, I'll move forward to this slide now on purpose. Thinking about the transformative test and how much, Jalissa said, I feel like you can see the original in a sense, but he added his own touch to it. Yeah, that's a great answer. You can definitely in these images see the underlying work, which would be the original photograph here. So the court did find that Andy Warhol had infringed on the copyright of Goldsmith, holding that the unlicensed images violated this original copyright because they were not transformative. The court stated that to be transformative, a work must be more than a reproduction of another artist's style on a primary work. The court noted that the unlicensed images retained essential elements from the original Goldsmith photograph, and that Warhol's modifications were merely magnifying or minimizing some elements from this first photograph. So the Goldsmith photograph was still entirely recognizable as the foundation of the unlicensed works in the print series. You can see, if you're comparing the original photograph here to these images here, that you can, the expression on Prince's face down to like the very glint in his eye, and the way that Prince's hair is shorter on one side in this particular photograph as opposed to like other photographs that were taken in this session, and the specific expression on Prince's face made it clear that these images in the print series were substantially similar to the Goldsmith photograph. So this was just a reproduction of that photograph. And you could still see the like heart of the work. And the heart of the work here would probably be the expression that he had on his face that she was able to capture as a photographer. And the heart of that work is very present in these works that were created by Warhol. I want to address a question that some of you might be having right now. So you might be wondering why Andy Warhol won in the right to publicity example that I talked about earlier with Marilyn Monroe, Elizabeth Taylor, and Elvis Presley pieces. But Andy Warhol did not win in this copyright case with the Prince images. So it's important to note that there's a difference between the right of publicity and copyright infringement. So right of publicity would be a property right in a human being and their like image and identity. And copyright does not have anything to do specifically with somebody's image. Copyright could be about a work of art that has to do with anything. And right of publicity is about if the artist took the literal depiction of the original work and just redid it. And copyright is about if the artist took the original message of the first image and changed it. So if in the Prince Andy Warhol case that we just talked about, Andy Warhol did not do that. He didn't change the original message from the first work. Does that make sense?
It does, but it brings up a question of the photographer that took the picture of, let's say, Marilyn Monroe. Could she have or he filed a copyright claim against Andy Warhol?
Yeah, so when I read this case that had to do with right of publicity, they didn't talk about copyright. So I actually don't know if, I assume looking at these photos that they're probably, from these images, that they're probably taken from a photograph, but I don't know if that for certain. But if this is like a replication, so if this image of Elizabeth Taylor is a exact replication of a photograph, but just in a different format, then definitely there could be a copyright issue there. But it's also could be true that Andy Warhol like looked at multiple different images of Elizabeth Taylor and created like his own original image based off of those. And in which case there wouldn't be a copyright issue. So then I'll just reiterate that the difference between the right of publicity and copyright would it be that right of publicity is a property right in a human's image and identity, and copyright doesn't specifically have to do with someone's image. Copyright could be about a work of art that has to do with anything. So right of publicity is about if the artist took the literal depiction of the original and like redid it, so like made a duplication of it. And copyright is about if the artist took the original message and meaning of the first image and changed it. Okay, so how can mint artists avoid copyright infringement when they're using photographs as references? So this is the most important question. So as an example, you may be creating a portrait of Ruth Ellis and would like to use a photograph or a few different photographs as a reference when you're creating this portrait, but you want to avoid copyright infringement. So based on the Andy Warhol Foundation case, to avoid copyright infringement, I advise that mint artists should not just reproduce one photograph of an individual in the medium of a painting, a charcoal sketch, or a pencil sketch, or like anything else like that. Artists may look at photographs of individuals that they are portraying in order to depict that individual's unique expressions, body language, or different features. But an artist should use these photographs only as a reference and create a work pulling from elements inspired by each of these photographs. So an artist could pull like the eyebrows from one photograph and like the slope of a shoulder from a different photograph and the person's smile from another photograph, and combine these to create their own like original expression. However, they can't just copy one photograph in its entirety. If an artist's portrait is substantially similar to a photograph, and so that would mean that the photograph is significantly recognizable within the artist's reproduction, then mint could be liable for copyright infringement. So down here, I have 3 different images of Ruth Ellis. You could, if you were making a portrait of Ruth Ellis, you could take different parts of each of these photographs and use them in your own work, but you couldn't just copy like this photograph is in its entirety and make a painting based off of that. That could be copyright infringement. And I actually have a pretty good example. I don't know if we have this artist with us today, but this is a piece that Vicki Elmer showed me, and it's beautiful. I'm in awe. And I actually, when she sent me this, realized that it looked familiar because I had used this image in my previous slide. So this portrait here could be copyright infringement because if you look, it's substantially similar to this photograph right here. The artist could have pulled like this, the look in Ruth Ellis's eyes or her smile, and used that in her painting, but she can't copy this photograph in its entirety because that could be copyright infringement.
So what would the artist do if, in this case, this is a pretty close representation to the original? What would they want to do? Would they want to just change the look on their face, or how would they proceed to avoid copyright infringement?
Yeah, so they could definitely change like the look on her face so that it's not like a replication of this photograph right here. So it's hard when this is already created, but just for like future reference, when you're making a portrait of someone, like you could really like the way that Ruth Ellis looked in this picture and want to include that in your portrait of her, but you can't use the entirety of her of this photograph here in your portrait, because then you would be infringing on the photographer in this image's copyright that they have over this image.
Could Eleanor just reach out to the estate and get permission?
Yes. So she wouldn't be reaching out to the estate here. She would be reaching out to the person who has the copyright on this photograph. So for right of publicity, when you're seeking permission from the person who you are replicating. And then in copyright, you are seeking permission from the person who owns the copyright. So in this case, it would be the photographer.
So even if an artist makes like a cartoony style of this picture, would it still be considered like copyright infringement?
Yes, it definitely could. And I'm thinking back to the Prince case that we talked about. I'll go back to that slide because that's a good example. So these aren't super like realistic. You can see that Andy Warhol used different colors and he kind of like flattened out their features. They're not cartoony, but they're also not like hyper realistic portraits. But that still would be copyright infringement because you're pulling from the way that the person looks in this photograph. And you're pulling like the exact way that they're looking and the exact expression that they have on their face. Does that make sense?
Yeah.
Yeah, so if you're doing like a cartoon image of a person based on a photograph, you're not going to want to just merely replicate that photograph, but in like a cartoon painting or drawing. You're going to need to use multiple different photographs as reference to make your own original expression of that person.
I used a picture of like a model from Pinterest. And like now that we did this, I'm slightly concerned because I did sell well, I don't think I didn't sell anything like this yet, but one of my mom's friends did ask to have one. So like this was the image.
That's beautiful.
Thank you.
So you're asking if you would be in trouble if you sold that image.
Yeah.
Are you selling it to your mom's friends, or are you just giving it as like a gift?
She wanted to buy it from me.
She wanted to buy it from you. So if that's a just literal, if that's a if this is a replication of a photograph that you saw on Pinterest, then you could be subject to a copyright issue there. If you are just selling this to your mom's friend, I would think that you would be okay. Especially if you weren't selling a lot of reproductions. I kind of talked earlier about like the first work that you create and sell, you're usually okay with that. It would be if you're selling like a bunch of reproductions of this. And I would especially think that if you're just selling this to your mom's friend, then that would be okay.
Okay. Thank you.
Yeah.
But if you're selling 6 or 7 different copies at different places, that's where you might start getting into trouble. Is that multiple people, multiple times? Is that the difference, do you think? Between
Yeah.
once to, yeah.
Yeah.
Or posting it on Etsy for sale, where it's a public forum where lawyers from all over the world can see it.
Yeah.
You know, so yeah, I mean, an Easter market sale, you have very small exposure, but if you put it on a national or global site, you could get in some trouble.
Yeah. I would think that if you were selling it to your mom's friends, no one would really know that you were selling this and you would be fine. But yes, if you were like posting this for sale, different places in person or online, that's when you would probably be in more trouble for it.
Right. And you can also go back into it, and say, I did some more thinking about it. I did some more work. I want to do some more work on it, and then add it and make it add more meaning and make it more your own,
Yeah.
less like the original piece. So there's that too, where you can use some of the transformative properties and turn it into your own thing and add, and that makes it, more legit. And honestly, I've been involved in art making and art buying and in both as a buyer and collector and as somebody who works with, with art for a long time. And this, just came up pretty recently in the past year or so when we were doing these portraits. So I think this is the kind of understanding that isn't widely out there. I think there's probably a lot of artists who are 30, 40, 50 years old who don't pay attention to the right to publicity and even the copyright issue discussion that we're having here with you right now. So, but we thought it was important because we are going to be doing these portraits this summer, and we want your work to, to be something that can be held on to by collectors and shared and resold for years to come.
Plus, it also provides protection for your work when you become famous. And so no one is taking your work, right? So it really protects all artists, all photographers, it protects your work and your livelihood.
Yeah. Yeah. And we want to respect other people's copyrights because we want our rights and copyrights and work protected as well. So Kelly's right. It's, it's sort of a important for us and for the world of artists out there. All right. Well, I just want to tell you, Maddie, this has been wonderful. It's, you've done a fabulous job of taking complex topics and putting them into, I think, terms that we can understand that are fairly concrete. And I really, really, really appreciate it so much.
Yeah, thank you. And thank you so much for having me.
Thank you so much. It was excellent.
Thank you.